Welcome, students. We're going to take some notes on the judicial branch. This will be part one of two sections of notes. So if you are working on part one, make sure this is the notes that you wanted. Part two will be separate. Let's take some notes. Judicial branch. Judicial power. Judicial review. It's the power of the court to determine the constitutionality of government action. Now, keep in mind that the judicial branch, the Supreme Court, their original purpose was to hear court cases, arbitrate between states. But since the court case of Marbury versus Madison, that was the first case to set the precedent of judicial review, that the Supreme Court not only hears court cases, but they also interpret the intent of the Constitution. And so you will have some judicial philosophies that will emerge because of this. And the two big judicial philosophies that we have currently today are the judicial restraint or originalism, and you also have judicial activism. Judicial restraint is following the original intent of the founders and sticking closely to the past precedent. Judicial activism, on the other hand, is interpreting the Constitution in light of changing social and political goals. Now, if you are thinking of conservative versus liberal or progressive, when you see both of these, you are correct. A more conservative justice would see the past as the torch to the future, whereas a progressive or liberal justice would say, no, we need rapid change now, and through the Constitution is how we have change. Now, a judicial restraint or judicial originalist, they are somebody who is in favor of laws that are needed to change, but not in changing the Constitution. That's the difference there. They believe the Constitution is set up in a certain way that it's important to preserve, but those laws within the nation can change as society changes. So they're not just simply into simply preserving the past, but the past structure, the foundation, so to speak, needs to stay the same. Judicial activists, on the other hand, they want to change the whole foundation. Judicial branch. You have the role is to interpret laws, the Constitution, and settle disputes. As I had mentioned earlier, settling disputes was their original intent. However, Marbury versus Madison would change that. Needs arose from the Articles of Confederation. If you remember, the Articles of Confederation was our first form of government. It was what explained the roles of the Second Continental Congress during the American Revolution, and it served us a few years after the American Revolution. However, there was a lot of problems with the Articles of Confederation, one of those being that there was no judicial branch. So the Constitution would create that. Federalist Papers in number 78 says the judicial branch is the least dangerous branch. Which is kind of funny because the judicial branch has the most power, arguably, today because of judicial interpretation, judicial power, judicial review. However, back then it was just to settle disputes. Important part to understand is that there's a dual court process. We have both the federal court system and we also have the state court systems. And within both, we do have a hierarchy. So you do need to know that we are a dual court system, a federal court system and a state court system, depending on which laws you have broken. There's also a military court system, military tribunal, but that doesn't count in this dual court system. That is separate, the JAG court system. The Supreme Court and inferior courts are in the federal court. You also have state Supreme Courts as well at the state level. So let's look at state courts first. State courts, trial courts, superior court. This is an example right here of El Cajon, downtown El Cajon. Civil or criminal trials that may be held before a single judge or a jury. So if you are convicted of a crime, you will go first to a superior court, as you see right here in downtown El Cajon. Intermediate appellate courts stand between the trial courts and the state Supreme Court. So if you are convicted of a crime by the trial courts, while in jail or prison, you can appeal to the appellate courts. If your appeal is seen as worthy, you can be heard by them. And then they can also refer you to the state Supreme Courts. So it goes up the ladder. The state Supreme Court is the highest court in the state judicial system. So you need to understand that we have this three-court system here in the states, that we have the trial courts, we have the intermediate appellate courts. To appeal something means to request, kind of a formal request, to change something. And so to appeal on something is that appellate courts, and then the state Supreme Court is the highest court in the state level. That is different than the federal Supreme Court. Let's look at the federal courts. The federal courts, very much the same. We have a three-tier system. We have the inferior courts, which are the district courts, first to hear most federal cases. There's 94 districts, each with a bankruptcy court plus U.S. court, international trade, U.S. court, and federal claims. You have a court of appeals is the second layer. They hear cases that have previously been ruled upon and look for errors in case decisions. So not every district court ruling goes to the Court of Appeals. However, when there are potential errors, you can appeal to the appeals court. It can't just be a request for a new trial, like at the state level. You can't just request a new trial. With the appeals court, it has to be either an error that was done or new evidence, things of that nature. And then you could make it to the Supreme Court, which is the highest court in the United States. Just like the state has a Supreme Court, the federal government has a Supreme Court, the highest court of the land. And so with the court structure, settling disputes, the Supreme Court does hear those high disputes there. However, their main focus has been in interpreting the Constitution and seeing the constitutionality of laws passed by Congress. That's been the most recent, in the last 200 years, role of the Supreme Court. As you can see right here, the federal judicial circuits, you have different circuit courts there. The Supreme Court, you can see the new Supreme Court justices there. The newest ones being Kavanaugh and also Gorsuch there. You don't need to write these names down, but you do need to know that we do have one Chief Justice and 8 Associate Justices. A Chief Justice is the main of them, whereas the Associate Justices are the other 8. The Chief Justice only has a few minor extra roles. However, all of their votes do count. And as you can see, the C versus the L is where they lean more liberal versus more conservative. As you can tell, all of the female justices on the Supreme Court, they lean more liberal. But then you do have one, Stephen, who leans liberal. You do have an African-American male on the Supreme Court, Clarence Thomas, who actually leans more conservative than liberal. You don't need to write those names down. Selection of judges. The federal justices appointed by President and approval by the Senate. And in the last 4 years, we've had 2 Supreme Court justices added to the Supreme Court, both Neil Gorsuch and also Brett Kavanaugh. And so maybe you remember the president in 2016 during his presidential election, President Donald Trump promising to elect conservative justices. And he has made good on that process. However, a president can't just have any justice appointed to the Supreme Court. The Senate has to approve it. Now, you might be asking what causes a president to be able to appoint a Supreme Court. That's if a previous Supreme Court justice, one of the 9, has either died or retired. And that has happened in the last 20 years. The senatorial courtesy. State's ranking party senator must approve appointees. So the senatorial courtesy, they must approve those appointees. Unusually shares similar ideology, or usually, not unusually, usually shares limited or similar ideology as the president that's appointing them, kind of a litmus test, so to speak. Very important to know that the president appoints, but the Senate approves. Terms and pay. Constitutional courts appointed for life. Good behavior. So if there is a Supreme Court justice or a justice of any of the courts that has been seen unfit for the job, they can be removed. May only be removed by impeachment. So it's a formal process. It's not easy to remove a judge. Special courts appointed to 15-year terms. Retirement, rule of 80, full salary. So if you make it to 80 years of age, you will get your full salary for the rest of your life, which would generally be around 20 or so years. 65 with at least 15 years of service, you can retire. So you can retire at age 65 if you have at least 15 years of service and receive much of your pay for retirement. Supreme Court operations. 1-year terms, October to June. So they serve from October to June. Rule of 4. 4 justices must agree to hear a case. So when it comes to the judicial term, the Supreme Court, they are obviously for life. They rule until they retire or pass away. But their term is from October to June. They usually rule or lay out, reveal their big court decisions in July that they've ruled on from October to June. If 4 justices agree to hear a case, it can be heard. Both parties file briefs, written documents filled with the court before oral arguments begin. So there is a brief that is that both parties going before the Supreme Court must write. Reveal relevant facts in previous cases. So again, remember the Supreme Court, those justices are very knowledgeable because they not only rule on a current matter, they have to know all the rulings historically to be able to back up their ruling. Amicus briefs, those are filed by friends of the court and those with a substantial interest in the outcome of a case. These are usually special interest groups. The amicus briefs also helps out with the written documents before the court and the oral arguments. Because the Supreme Court does hear from different sides, the plaintiff and the defendant, at that high level of court. Last thing here, we have the Supreme Court operations. Oral arguments are usually 30 minutes each. The court conference, discussion in order of seniority. So these 9 justices get to share their point of view based on seniority. Who has been in the court the longest. Stare decisions. Let the decision stand. Could be a ruling. meaning future cases will be based on precedent. So if we have ruled previously in the Supreme Court on a matter, then unless there's substantial evidence to go against that, they use those previous rulings to help them with current rulings. So that's why when you have issues of abortion that are raised, Roe versus Wade is usually cited because that was a previous court case. And you have other court cases that would be similar to that. So that's part one of the notes. We will take part two at a different section of notes. Thank you very much.